Welcome back to the Wealth Actually podcast, the show that features experts, entrepreneurs, and commentators that will give you the right knowledge, planning, and guidance so you can preserve your assets and enjoy your wealth. Learn more and subscribe today at wealthactually.com.
This podcast is for educational and entertainment purposes. It is neither investment, legal, nor tax advice. It does not represent the opinions of the employers of the host or guest.
Welcome back to the Wealth Actually podcast. I'm Fraser Rice. Gene Hackman was one of the great actors of our generation. Unfortunately, his estate planning has left behind a ball of confusion and conflict for his heirs. Lawrence D Mandelker, who is a partner at Venable in the New York office, is going to help us think through the lessons we can learn from this sad tale. Welcome aboard, Larry.
Thanks for having me, Fraser.
Oh, this is, I wouldn't say it's fun talking about someone's estate, but this one's particularly interesting. We all remember Gene Hackman from Hoosiers and Superman and Mississippi Burning and all sorts of great movies. Unfortunately, his end was sad and as it turns out, complicated, and something where, from an estate planning perspective, we can probably learn a lot. Take us through a little bit about where Gene's estate kind of went from and ended up as far as a fact pattern.
So, the news sort of surprised all of us when we heard that he had died. And then over the next couple of days and weeks and even months, more and more detail came out. And as you said, it was pretty disturbing. But it seems as though Gene Hackman was a very successful actor, and he engaged in estate planning. He worked with attorneys, which is always a good thing to do it, to work with people who are experts in the field. And he had a normal estate plan. He lived with his wife. It seems like he had a little bit of a fractured family. It was not his first marriage. And, as we learned, after he signed his estate planning documents, sort of things over the next 20 years sort of changed for him. He had some health issues. He was suffering from advanced dementia at the time he died. And as we know, his wife died from a virus apparently a week before. And then as the details came out, we kind of learned that he had the advanced dementia. There was a fractured family. The wife and his kids did not get along so well. It's sort of unclear what the situation was with, how much contact he did have with his children. But he had a will. He had signed it, 20 years before he died. And, the facts changed. It looks like he hadn't reviewed it in a while. His attorney died. So we have a sad situation here.
Many lessons to get from that. Let's start with the first one. He definitely had sort of dementia situations, cognitive dysfunction that eroded over the course of time. Maybe take us through a little bit about the scope of that issue, and it affects lots of people and a growing number every year, and some things that should be in place because of that.
Yeah, we all think we've got a lot of time. And for someone who gets a diagnosis of dementia, it's sort of a warning sign as soon as that happens that, we never know when our time is going to come. But the dementia is sort of the warning. Maybe you're entering the second half of the game or the fourth quarter of the game. So maybe you should start getting your affairs in order while you still can. So it's a good impetus to do that. When we're looking at estate planning, there's, you can do different types of estate planning, but really think about it as you can do it for yourself, you can do it for your loved ones, and then, depending on the nature of your asset, you can do it for tax purposes. But, getting the warning that you have dementia doesn't mean that you can't sign a will, doesn't mean you can't do any estate planning. It just means that, you're probably heading towards a situation where you are going to face a number of years during your life where you can't make the same decisions on a daily basis for your own benefit that you can today. And, going back to that idea of the first level of estate planning is for yourself. So you want to make sure that you've put in place a plan of who's going to make decisions for you when you can't make those decisions, rather than having, those people fighting amongst themselves to decide who's going to do it. Let you're empowered to do it yourself.
It goes so far as to reiterate the notion that you should review these things periodically. The idea of making decisions around healthcare, making decisions around financial situations. We were dealing with a sizable estate, and to have that in a confused state, as someone's health starts to decline, that's a dangerous place to be.
Yeah, absolutely. I mean, at the very base, you want a healthcare proxy and a power of attorney. The healthcare proxy is going to name a healthcare agent to act for you, to make your decisions when you can't make them. And the power of attorney is going to name someone who can do anything that you can do by signing your name. So they can, sell your house. They can buy a house. They can take out a mortgage. They can buy stock. They can sign your tax return. They can pay your electricity bill. So, the people that you trust to do those important jobs may change over time. So, when your kids are young, and if you've got a teenage child, maybe you don't trust them, but as they are in their 20s and 30s, and at that point, when your kids are young, maybe you're naming your siblings as these agents, or good friends, or trusted advisors, whether it's your accountant or your attorney, people that you've known for a while whose judgment you trust. But then when your children get older, that changes a little bit. Maybe now you start trusting your kids to do that. Maybe your advisor is no longer working, or you've moved on to a different advisor. Maybe your siblings have their own health problems, so they're not able to do it. So it always changes, and it's always something that you don't need to look at the documents every day. And I sort of tell my clients, keep the documents someplace where they will be found, but not where you see them every day.
And the backup to that is don't leave it in a safety deposit box at a bank, where necessarily the bank may have trouble getting to it if you don't have those documents in place, or they are in the vault.
Yeah, that's the thing that's one of the first things you learn out of law school as a trust and estates attorney, that you need a court order to open, in New York at least. You need a court order to open up a safe deposit box after someone died. So if the will is in there, you've increased your complexity, you've increased your costs, you've increased your time just to get the will.
So let's get back to the important notion of implementation, and then the close cousin to that, monitoring the estate plan as it goes forward. A lot of what's going on in the Gene Hackman estate is going to be related to titling of assets and making sure that they are in the different entities that were set up, making sure the designations are in place, and then understanding that is where that it follows the intent of Gene going forward. What do we learn on that from what we had here?
A lot of our clients come in, they sign the documents, and they think, wait a minute, I'm done, right? And, sort of there's a next step. You want to make sure that you've implemented your plan. So that means, if you have a revocable trust because you want to avoid probate, well, the assets have to be in the revocable trust. You actually have to retitle your assets. If you want to update your beneficiary designations on your retirement accounts or on life insurance policies, it's not enough to just say you want to do it. You have to actually fill out the forms. You have to send them in. And, practice pointer, you really should be following up with the insurance company and say, can I have written confirmation that you've done it correctly? If you name 3 children and they only put down 2, then they're only going to pay it to 2 kids. So you want to always check and recheck to confirm that everything that you've done or everything that you wanted to do has actually been put in place.
And this was a case where sort of the way of going about it, where they set it and forget it, really hurt things going forward.
Yeah, he signed his will and he didn't review it, it seemed like, for quite some time. So he named as a fiduciary, he names his attorney. And meanwhile, his attorney predeceased him. So we don't know if that was because maybe he lacked capacity to change those documents, at the time the attorney predeceased, or he just didn't look at it. But in any event, if the attorney's, getting older, something's happening, you should know, you should constantly monitor if these are the people that you're counting on to take care of yourself, and you want to make sure that they're in a good position to do that.
I always try to tell people that it's a good idea to have the people who staff the different roles in your estate plan to be, rule of thumb, hopefully 10 years younger than you are, and maybe more, just so that you don't have these types of issues.
That's a good rule of thumb. You usually don't want someone older, in the event that you really have nobody else, you have a small family, or you don't trust someone, or maybe the family dynamics is really shifting drastically, then sometimes you'll just maybe add an extra person in the hopes that, well, this person probably won't act, but if something, happens to me, something surprising happens to me, that at least someone's there to be able to name someone else to act. So yeah, naming younger people, naming more people as backups, that's always important.
Well, and that was sort of an unintended good thing that happened in this estate plan. It sounds like he had a second successor in place because the circumstances around the joint death were a little peculiar. So having someone else in place has helped a little bit in this situation.
Yeah, absolutely. It's that second successor. So it's not only your primary agent and a successor, but sometimes having that other successor. It's contingencies. I mean, we're always worried about, the fact, when we draft documents, we always, in part of our plan, try to figure out, okay, well, what happens in the family disaster situation, right? You're all on the plane going down to Disney World for a big family reunion, and the plane goes down. Who outside of the immediate family do you want to get the documents? But we've got to plan for all contingencies when we do this.
One of the things that's sad about this case is that it's being played out in the public. You hear about, estate planning in People magazine is not exactly something we expect. But the fact of the matter is that this is sort of played out publicly when in many cases, I'm sure that Gene didn't intend for that to happen. Maybe talk a little bit about the privacy and the confidentiality issues that are at play here.
Sure. So your will is your will, and it's just a document until it actually gets probated, which means the court goes in and stamps it as being an official document. But for that process to happen, you have to go to court, you have to file the will in court, and that means it becomes part of the public record. And whenever there's a celebrity death, sort of, a week or 2 weeks afterwards, the will comes out, and it's always in, a newspaper or magazine. And, as someone who represents highly visible people, they don't want that. That's their personal issues. Gene Hackman, lived a quiet life. I don't think he wanted people to know what his relationship was with his family, etc. Now, one thing that he did do was he used a revocable trust. A revocable trust is also sometimes referred to as a will substitute. That does not get probated. So that does not become part of the public record. So where it says that his assets go into a revocable trust, it doesn't mean that he didn't leave it for his kids or he didn't leave it to charity. We just don't know. And frankly, it's none of our business. We don't need to know how much money he had. We don't need to know what he did with his money. You don't know what he spent it on a daily basis. And, again, as someone who represents, highly visible people, athletes, entertainers, they don't want, they've got enough public, viewing of their life. They want a little bit of privacy, and we should all sort of give them that.
No question. And the fact that, I imagine Gene, he kept a low profile, especially in the later stages of his life. He wanted to be remembered, I think, for his acting career and the legacy he left behind, not, sort of the final years and sort of the way he lived that.
Absolutely. I wouldn't want my neighbors to know what I'm doing with my money. I don't deserve to know what they are. And, these people just have maybe it's a cooler job and it's a more visible job, but give them that common amount of decency.
One of the things that I think is a real cautionary tale here is that sometimes the boilerplate in these documents is particularly important, and the circumstances of Gene and his wife's demise have created a little bit of sort of a walk into the gray area of how things should be applied here. Maybe take us through that. This involves sort of the timing of death and how that applies to the implementation of these different vehicles.
So when we say boilerplate, we're kind of talking about the general language in the will. So when you have a will, you talk, when your client tells you what they want to do, and we're drafting their will to reflect their wishes, there's certain provisions that we'll always have in that will. Provisions on how the will is going to be administered, what laws are going to apply, things like that, tax provisions. So, that's really what we talk about as far as boilerplate. The problem is that boilerplate sometimes is more important than the actual dispositive provisions of the will. Those provisions that say, 50% goes to my son and 50% goes to my daughter. Because depending on how it's administered, the 50% could turn into something very different. And this is a perfect example of that. Gene survived his wife. So his wife died, and then a week later he died. And her will said, if Gene survives me, if he's alive when I'm dead, then then the money goes, this way. The money goes to him. And later on, and then it said, if he doesn't survive me, if he's not alive when I die, then the money goes to charity. And the document said, well, if Jean doesn't survive by 90 days, then it's treated as if he predeceased her. And really, that little provision rewrites the whole will. It's done for the reason to make sure that, well, if Gene wasn't around, if we died in a common accident and maybe I died, we died in a car accident and I died on Monday and he, survived for 3 days in the hospital, he really didn't have time to change it. He didn't benefit from it. So I don't necessarily want it to go to him. I want it to go to who it would have gone anyway, if he didn't survive. So that's the purpose of that type of provision. But really, it turns things on its heads. And I really think that the lesson from this is, especially for the do-it-yourselfers out there who, go online and they try to copy a will and, type in their name and say, oh, this is the provisions. You don't know what's hidden for computing purposes. You don't know what's hidden in the code, right? You don't know what else is in there and what changes those could have on the rest of the document and the plan.
Well, and to put numbers around this, depending on how this gets sort of disseminated and understood, this could be $80 million going to the heirs or $80 million going to charity. With some, you can understand that some people are going to have some questions about that going forward if you aren't clear about what the intent is in your documents and making sure that that's understood in that language.
Yeah, like I said earlier, these little provisions that you tend to gloss over can really change the entire estate plan. This is a swing of $80 million. So, that's going to be a huge difference.
For the do-it-yourselfers, I think it's also you said it before, but I'm going to reiterate it because I think it's important. I think the idea of getting sort of estate plan document by auto generation really sort of is going to cause some issues around this, where people put things in place where they don't understand how the levers get pulled and the directions that the estate plan can go, and will frustrate intent. So this is my little sort of bromide to say, even if you are using those documents, it's a really good idea to have them go through a lawyer as well, so that you understand how each of the clauses can impact these types of situations.
Yeah, I mean, I sometimes say that if you're being responsible enough to do estate planning, you're thinking ahead, you want to plan, you want to empower yourself, you want to take matters into your own hands so you get to decide who gets things and how it's going to be done, then you really should go the next step to do it. Otherwise, you're really taking a big risk. I could get behind the wheel of my car and, blindfold myself and start driving to the store, and I may make it. It may work out perfectly, but it's not necessarily a good idea to do it, even if it works out.
To go back to the other parts of the fact pattern here, number one, intent can shift. And, if you get into places where capacity or dementia starts coming into place, it's important to review these things. And secondarily, you can even have the will or the revocable trust say what you want it to say. But if you don't have that titling and designation of beneficiaries and various things line up with the document, your intent can get distorted quickly.
Right. You know what you know, but you don't know what you don't know. And that's the dangerous part.
Yeah, I mean, we can look into the crystal ball for people and take care of a bunch of risks, but certainly not all of them.
Right. And, to your point, I think you brought up a very good point just now, and thank you for raising it. There are certain things that are done when you sign a will that can help support the will in case of a later challenge, especially if you have incapacity. So when you're dealing with an attorney, in some states like New York, for instance, where I'm located, the fact that an attorney supervised the execution of the will means that there's a legal presumption that it was executed correctly. So when you bring the will to court to probate the will, you have to prove that it was executed correctly. If you had an attorney supervise it, you don't have to do that. So someone who's looking to object to a will, to contest it and say that's not a valid will, you've made their job infinitely harder by just having an attorney supervise the execution.
Which some people are discovering. For instance, Aretha Franklin's estate has this issue where another will has surfaced that was apparently found in a couch somewhere, and they're going to litigate as to whether that's valid or not. And you can reduce the stress on the executor and the ultimate heirs and family members if you get this stuff tied up in a nice bow ahead of time.
Absolutely. And there's a lot of things that go into the will execution meeting where you sign your will. There's a lot of things that go into the whole process of your estate planning. Dealing with correspondence, dealing with, discussions that you have with your attorney, and especially for people that are concerned about having a will contest or concerned about dementia and people saying maybe they didn't understand the will, working with someone who is well-versed in what they need to be able to prove the will execution is extremely, extremely important. Can't be said enough.
Great stuff. Larry, any final points?
Again, it's just, if you should be taking these steps, regardless of how large your estate is, and you should be working with someone who's well-versed, who's going to be able to give you the information that you need to get done what you need to do to effectuate your wishes.
Terrific. How do listeners find you?
I am a partner in the New York office at Venable. They can email me at lmandelker@venable.com, or, look me up and give us a call if you have any questions. More than happy to talk to anyone.
I'll have that in the show notes. Thanks so much for being on.
Thank you. I appreciate this.
This podcast is for educational and entertainment purposes. It is neither investment, legal, nor tax advice and does not represent the opinions of the employers of the host or guest.